So welcome to the session today. My name is Tracy Carluccio. I'm Deputy Director of Delaware Riverkeeper Network.
I'm Lauren Williams. I'm an attorney at Curtin and Hefner in Doylestown. If you were here last year, one of my colleagues, Jordan Yeager, spoke on the Environmental Rights Amendment. So we do a lot of work with Delaware Riverkeeper Network.
So today we're going to be talking about defending our communities from industrial development and what kind of municipal planning and zoning we can put in place in order to protect our communities. I'm going to let Lauren step up there, and
Okay.
you can see our names here and the companion text. Now the companion text is this book, Defending the Environmental Rights of Pennsylvania Communities from Shale Gas Development, but it also applies to other sorts of industrial development. So make sure you get one of those. I think Julio handed them out. Also, for background information, having to do with shale gas development is a book that Delaware Riverkeeper Network published called Unsafe and Unsustainable, and you're welcome to take that as well.
And the text is also available online. When you get access to the presentations, because I believe everybody gets access to the presentations, you can also go on the website. You can download the whole handbook. You can download chapters, whatever you want. You can download.
And that's the bit.ly right there, but you'll see.
And the guidebook walks through, and we're going to touch on some of these things today. But it walks through a bunch of these things, including some frequently asked questions about the decision from 2013 that really breathed new life into Article 1, Section 27 of the Pennsylvania Constitution, the Environmental Rights Amendment. We're not going to go through, and it sort of walks through these, and these are some things we're also going to be touching on today, which are just generally, when you sit down and you want to talk about protecting your community and what that means, you have to think about, first, what can your government do legally? What kind of authority does it have? What's important in your community? And also, how do we use the tools that are available to us?
So in terms of municipal planning, you may or may not know that townships are the oldest form of organized government in the United States. So they date back to the 17th century, and this is the way that communities organize themselves. So we have a lot of strength, particularly here in Pennsylvania, in that you can't do everything at the municipal level, but there's a heck of a lot that you can do, and that you can insist that your elected officials do in order to protect your community, your resources, the quality of your air and water, and that's what we're really going to focus on here today. What can you do at the municipal level? And municipal planning and implementation of environmental laws are based on these three basic principles: the power and responsibilities of local government to control activities within their jurisdiction. Notice that word responsibilities as well as power. We have power, but our elected officials also have the responsibility to do that. Local zoning is firmly entrenched in Pennsylvania law. It has gone to the Supreme Court. It's very, very clear that communities have the right to zone what they want in their communities, how they want to develop, how they want to protect, how they want to conserve, where they want to drive cars, whether or not they want certain development to come into their community. And ordinances are essential. And we're going to be talking about that, and Lauren's going to be walking us through some of the nuts and bolts of that. In order to prevent harm caused by industrial activities, and including gas development, it's really important for us to respect citizens' constitutional rights. And right now, Lauren's going to start out and kind of explain the framework for where that constitutional rights issue comes from.
Right. So I'm going to try to keep some of the legalese to a minimum today, and also try to get to the tools and strategies. So as I'm going through, I'm probably going to ask, just sort of do a poll, how many people are familiar with X or Y, so we can there may be certain parts that we can kind of just breeze through to get to the meat of everything. Now, just so I sort of understand who I have in the room, do I have any planners or lawyers in the room? We have one lawyer. Consultants, science type folks, engineers. Are most of you community members? Great, wonderful. All right. So what we're going to do is I'm going to give a brief background of sort of where things have come from as far as why, where the new landscape as far as the Environmental Rights Amendment goes, and also as well as zoning. So I'll start with Act 13 in Robinson Township. Sort of the fallout from that litigation. There's a lot of uncertainty still going on now, which I'll talk about, but there's also some guiding principles that are also pretty bedrock principles, particularly for zoning. And then we'll get into tools and strategies. Ordinances, zoning, what other types of ordinances are available to use. So, who knows generally about oil and gas development and zoning before Act 13? Nobody. Okay, good. Well, that's where we're going to start. So, particularly as far as gas development goes, municipalities had a limited authority. Municipalities' zoning authority is constrained by the Constitution. It's also constrained by the municipality's planning code. So Article 1, Section 1 of the Pennsylvania Constitution deals in part with property rights. So you have to allow, people to use and enjoy their property, but you also, it's one of those things, your rights and where the other person's nose begins kind of concept. In addition, we have Article 1, Section 27, which the lady from DCNR nicely spoke about this morning. In addition, the municipality's planning code is a statute that lays out sort of what I call is it puts the meat on the bones of the constitutional standards, but it also provides other statutory specific requirements. So one of them is you have to allow for the reasonable development of minerals, but that's also including other land uses. So, and it's not just gas development. It's, quarry, coal mining, in addition you have other land uses, conservation, protection of drinking water, because the municipality also has obligations to protect people's drinking water, to protect their air quality, to protect agricultural soils. So it was a balancing act, and that's always what zoning has really been about, is a balancing act, which we'll talk about a little later. You could use your zoning authority to regulate where, for example, drilling could take place, where you could put a well site, where you could put a compressor station, but you couldn't regulate the technical features of the operation. So you can't regulate how thick the casing in a well site, in a well bore has to be. You can't regulate, how much, those sorts of things. If you want to go ahead and flip through. So what happened in 2012 sort of makes me feel a little old because I was a very new lawyer at this time. Right. So the legislature passed Act 13 of 2012, which did a whole bunch of things. One of which it purported to create what a uniform zoning scheme for oil and gas operations. We've come to call it the one-size-fits-all zoning scheme. It's basically was designed to create a statewide zoning scheme that required municipalities to put oil and gas development activities pretty much everywhere. So you had to have a well site in every district, whether it was residential, agricultural, commercial, or industrial. You compressor stations could go in places that people might otherwise not put, where people might not otherwise put them. Pipeline, seismic operations, you name it, you could end up with a hazardous wastewater impoundment in your resource protection zone that was set aside for drinking water, which is really big in a lot of rural areas because so many people rely on well water. So this provides some of the nuts and bolts. I think we can probably skim through that, but that's sort of the basic thing. It was a really big change on a massive scale. So what happened is myself and several other attorneys represented a number of clients in a constitutional challenge to the law. There were 7 municipalities. Most of them were on the western part of the state, but there were 2 on this side of the state, Nockamixon Township and Yardley Borough. We had 2 municipal officials from the western part of the state who sued both in their official and personal capacities. We had Delaware Riverkeeper Network, and the Delaware Riverkeeper Network, and a doctor. And the challenge had a number of different parts to it, but one of the biggest parts was challenging these uniform zoning provisions. What I should have said earlier was one of the other aspects of Act 13, which I'm not sure it's going to be later in the slides, was a section that really tried to take away municipalities' ability to even regulate just general environmental aspects of operations that they actually had the ability to manage. So there's a state stormwater management act, and there's certain generally applicable stormwater regulations that a municipality might have that apply, across the board, whether it's oil and gas, or whether you're a cement plant, or whether you're something else. And so that particular section of the law really sought to wipe those out too. So bound up in our challenge was sort of, were two different primary arguments against, saying why what the state tried to pass was wrong, was a violation of constitutional rights. So the first one, the first big argument was based in Article 1, Section 1, property rights, based on what we argued was basically that the state was forcing municipalities to enact zoning ordinances that would violate the constitutional rights of their citizens. And we won on that argument at the Commonwealth Court. The Commonwealth Court is one of the two intermediate appellate courts in Pennsylvania, but it's also where you bring an action if you're suing the state. You don't start like in the County Court of Common Pleas. So we won on that in the Commonwealth Court. We also had got one Pennsylvania Supreme Court justice who agreed with us on that when we went up to the Pennsylvania Supreme Court. The second argument we made was based in Article 1, Section 27. Now, most people thought at the time that we were crazy for any number of reasons to bring this action, but particularly to bring it a challenge under Article 1, Section 27, because up until this point, most people saw that, even though it had a lot of strong language, the people have a right to clean air, good water, a healthy community in which to live, it had generally been seen as toothless since it had been enacted in the 70s. So most people thought we were a little, wacky.
I'll read you Article 1, Section 27, which is the Environmental Rights Amendment from the Pennsylvania Constitution, and we're amongst, there's probably only one other state that has as good an environmental rights amendment. It's very short. The people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustees of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people.
Quick question.
Yeah.
What did Justice Baer have to do with the Commonwealth Court decision?
Sorry, when the case went up to the Pennsylvania Supreme Court, at the time there were only 6 justices, because Justice Ori Melvin was having issues. So we had 3 justices who signed on to basically uphold the Commonwealth Court's decision, but did so based on the Section 27 argument. Justice Baer joined the decision, making it 4, thus making it a majority decision, because otherwise it would have been split 3-3, like if he hadn't joined on. But he joined on based on this rationale. So it was different reasoning, but the same result. So that's why I had that up there. Yes. That's one of our favorite political cartoons. One of our council thinks it's him, but with in the end, what happened is, we had this really great decision in 2013. One of the results of having sort of a split rationale in the decision was there's some confusion. Well, it really shouldn't be confusion, but some uncertainty about where the law is going to head next, because when you have a situation in which let's say basically we had 3 justices signing on to turn the law over on section 27. This is where it gets a little legally, and I'll try to keep it moving. And 1 justice on Article 1, section 27. It was definitely a majority to strike the law down, but not on the reasoning. And because it was only 6 justices, people were like, well, it's only a plurality, which is legal terminology for people saying, well, we don't really have to follow it. So where do we go next? So what's been happening right now since 2013 is there's been ongoing battles over what the decisions really mean. And I can probably, there's a little bit more I can add to this right now just because we had some oral arguments this week at the Pennsylvania Supreme Court, which were after we did these slides. So there's been some people who say, you know, this Section 27 decision and all the Robinson Township cases are just about who can do zoning. That completely misunderstands what the cases were about. Because we couldn't really, I'm not going to say we couldn't bring an action basically saying, no state, you can't take away our zoning. We actually brought a thing saying, you're forcing us to do something unconstitutional, you know? And so it's very much more than, you know, the state can do zoning, the local municipality can do zoning. There's also some remaining pieces of Chapter 33 of Act 13. Chapter 33 is where the zoning provisions were that are still being fought over, which I'm not going to get into that too much because it's not so relevant right now. And then there's this case called PEDF, which stands for the Pennsylvania Environmental Defense Foundation. They brought a suit actually that predated the Act 13 case, challenging leasing of state forests for gas development. And this week, that case was up at the Pennsylvania Supreme Court, as was the remaining chunks of our case. And one of the crucial things I really took away from that day were that elections matter. And we can't get into lobbying too much here, but the attorney for DCNR basically got up and said that the state was totally fine with accepting the plurality decision in Robinson Township as the law in Section 27. And there's another piece I'm forgetting at the moment. But it was really a complete change from how the state had argued the case before the administration changed. So it'll be interesting to see what kind of guidance we get from the Pennsylvania Supreme Court on Article 1, Section 27 that will hopefully provide some clarity going forward and some stronger legal, arguments. I'm not saying we don't have them now, but we get more pushback. And so what I want to get into a little bit is what are the things that we can pull out of what we have right now? What can we pull out to take to a municipality and say, look, you have an obligation to protect our rights. I have a right to use and enjoy my property just as my neighbor does. You have to find, you need to find the line where we balance all of our rights. And so one of the first things to remember about the Constitution, and this probably isn't quite right, what I should say is Article 1 of the Pennsylvania Constitution. Well, I guess it could be all of it. But particularly Article 1 is that it's a limitation on government authority. Article 1 of the Pennsylvania Constitution is the Declaration of Rights. It's where you find your freedom of speech protection, that the government can't, stop you from, going on a public corner and standing out there with a sign. And so it's a limitation on government authority. So when we think about something like the people have a right to clean air and pure water, it's a limitation on the government's ability to unreasonably infringe on your right to clean air and pure water. It may not mean, obviously there's always going to be, we breathe, therefore there's some sort of pollution. But it's the point of, we need clean air to live. We need clean water to live. We need healthy communities in which to live. The scenic values of the environment are an important part we like to go to parks. I mean, we're here talking about how important it is to protect the schoolgirls. So, that's one aspect of it. The second part of Section 22 talks about a public trust, meaning that the state has fiduciary obligations. Like if you manage a trust for somebody, you can't, screw with it too much. It's a similar concept. And so that's what, particularly when we're looking at Section 27, that's what we're talking about. Municipalities have an obligation to refrain from unreasonably infringing on your right to clean air and pure water. They also have an obligation, in the words of the Robinson Township decision, to refrain from permitting the unreasonable degradation, diminution, or depletion of your public natural resources. So that's the fish in the streams, your air quality, and other things. Of course, at the same time, as we started talking about earlier, it's the idea of balance. There's many rights in Article 1. A lot of times, particularly when you're dealing with zoning and environmental regulation, you're dealing with property rights. At the same time, property rights there's sort of two, and I think, can you go up on the slide a little bit? Oh wait, it's on the next slide, that's why.
Do you want me to go to the next one?
No, not yet, sorry. But it's the idea that you have to balance all these different interests. The idea that there's development that benefits a community to occur, but at the same time, there's a benefit to conserving the resources. There's different land uses. So like the MPC talks about all the different things that a community might need, residential development, but at the same time it needs, if it has good agricultural soils, to preserve those soils for food growth. You might have, again, as I was saying, you might have somebody who really wants to develop their property, but it's going to have an impact on somebody and on neighbors' ability for clean air, pure water, that kind of thing. This is what the other thing I was getting at, where everybody has there's this protection on property rights. So at the same time, one of the things we've been arguing, and that I think that we argued in Robinson, is this idea that it's not just about developing property. Some people want to have the ability to go out on their back porch and have a drink at night. And not have like some screeching noise or some big waft of diesel exhaust. So it's finding that balance between the two, and that's really actually where zoning sort of began, was this idea of regulating nuisances but going further than that, trying to find the line between everybody's nose, so to speak, where everybody's rights kind of butt up against each other. And then this last one, in the I think it's the third sentence of Section 27, talks about generations yet to come. And so there's this balance between what we need and what we want to do and what's going to be pushed on to future generations. And I think the thing from this morning, from Cherry's talk, is so relevant to that are we going to keep kicking the can down the road? What are we giving our children, our grandchildren? I think is it a Native American thing about looking 7 generations down the road? We have to think about, what kinds of impacts are going to happen. Is it not going to be that bad now, but in the future we either don't know or it could be really bad? Is it something that compounds over time? And so that's where I know sustainable development is kind of a buzzword right now, but it was really interesting to see it show up in the Pennsylvania Supreme Court's decision, particularly as to Section 27, the fact that, again, it's about balance. It's about, we can have strong economies and strong and healthy communities. It's not, you're not just foisting something in there and saying, hey, you're going to have a job now, kind of thing. It's something that's really going to help the community get stronger. And that's sort of the other thing about the thumb on the scale. And this is from the Commonwealth Court's decision in the PEDF case that I was talking about earlier. So if you want to keep going on. Yeah, I think that's probably just another way of sort of saying the same thing. you focus on the community as a whole. So how do we really do this?
And maybe look at spot use.
Oh, yeah, the spot use thing basically just means that it's a different way of saying you're only focusing on a particular industry. So that's what we argued on the oil and gas development was, it's spot zoning is basically, in the traditional sense, is where you have a piece of property that somebody zones to either deliberately benefit or harm somebody. So like if you want to freeze a property as agricultural so it doesn't get any more developed, but it clearly just doesn't make sense, like that's spot zoning. Spot use basically is a similar idea when you're putting uses in a district, like you're putting an industrial use in a residential zone. It doesn't belong there, but you just want it to be there so people can do more with their land.
Did the decision allow municipalities to say no entirely to fracking, or just to say where it has to go?
It restored some stuff. We'll get to that in a second, actually. So how do we go about doing this? Just put the slide up just a little bit, because actually, this is one of the important parts of this. We need science, but not just the law. This idea of science-based decision-making is grounded in the language of the judicial cases, but it's also a little bit of common sense. When you're thinking about how do we protect our community, how do we know what kind of effects we're going to have down the road, and then craft a legal regime that's going to address that, you need science, not just the law. You need to understand how is this factory that's going to be permitted here impact the local community? How is it going to impact, how is this wastewater discharge going to impact the fish in the street? Not just now, but down the road, and are we even able to know? Things like PCBs and dioxin, things like that bioaccumulate over time. We can't just do I was just in the presentation on industrial stormwater discharges. It's this idea of how are we going to address these things that we're not even sure like exactly what they're going to do. And in some ways it's just like other rights. Like the government's going to think about, if I'm going to put a restriction on a public space, how's that going to impact people's free speech rights? It just gets a little more complex with something like environmental rights, because we need science too. And this is sort of just what we talked about. We need to look short-term and long-term, a one-time and a cumulative thing. And the difference with what we're talking about in this presentation as science-based decision-making is that if you're familiar with the Federal National Environmental Policy Act, that law only provides a process. It doesn't actually provide any substantive result, meaning you can go through and look at all the environmental impacts, but you can still do the bad thing you wanted to do anyway. This is more substantive in that you're actually sitting down to look at, okay, should this occur, and if it's okay to occur, is it really good here? And if so, how are we going to do that? I think science sometimes calls it the precautionary principle. And so some of the things to keep in mind as we're going through this, and some of the things that came out of the both the Act 13 decision, and I think a little bit, some of the principles were reinforced by the PEDF case. Local conditions matter. Particularly in the Robinson Township case at the Pennsylvania Supreme Court, the court kept talking about how diverse Pennsylvania is, how topography is different. You can't just put a well site, in the mountains and expect it to have the same impact as if you put it in Washington County. So it's this idea that local conditions matter to public health and environmental quality. The air you breathe is going to be impacted differently whether you live in a valley or on a mountaintop, whether you live next to a highway or next to a park. What is the wind and weather, what patterns, what is the seasonal variation? All these complex things, but that we can use science to get at. A second principle is that local governments have a role, and of course we've just talked about the duty that they have, but they have a role in environmental protection where we have a state this broad. Where we have, people who live in dense urban centers and people who live out, in very rural areas. And it's just, yeah, so it's sort of the similar concept that you have to look at things, while there is a role for, of course DEP has a role. It has a role in particular areas, particularly highly technical regulations that can go, let's say how many, what kind of equipment you need to put on a smokestack. But when you're really getting down to it, the local government still has the role to really look at, okay, where is this really good to go? And what kind of community do we want to build for the future? So I think is this the last thing before we get to
Maybe a couple more.
Okay, we'll try to keep it moving. So one of the other things is this idea that if you're putting uses in non-industrial zones, based on how the Act 13 decision came out, you're raising, if you're a municipality, you're raising a higher risk of challenge, or you may be raising a higher risk of challenge under, so this would be Article 1, Section 1, the property rights rationale that the Commonwealth Court used, and then Robinson 2 being Section 27. And so the issue with Article 1, Section 1 with the property rights idea, the basic zoning principles, which we're going to get into shortly, it's that you put different, you set aside areas of the municipality for different types of uses. You set aside an area for residential, for parks, for, for your commercial district, and then for industrial use. If you start putting industrial uses in areas that aren't set aside for that kind of use, you basically blow apart the whole zoning scheme. In part because it's incompatible with the other uses in the district. If you're putting a gas well site next to a house,
I think what Lauren, has made pretty clear is local conditions matter. I mean, when it comes down to tailoring a regulatory regime and a master plan or a comprehensive plan for your community, what you have locally matters. Where do people live? Where are the nursing homes? Where are the schools? Where are the playgrounds? In other words, you don't want to have an industrial site or big polluting trucks or rail cars or gas wells going in right next to where people live or where kids are playing in a playground outside of their school. You want to make sure that you can protect as much as possible the environment where people live. And then because of the Supreme Court decision and the Article 1, Section 27 basis that it was decided on, it's also really important that we think about the cumulative and long-term impacts of that. So when these local conditions matter, it's for today and it's also for tomorrow. And that's where we step up to trying to develop a little more complexity in terms of how we actually do this. So we regulate our land uses, such as gas development. It could be quarrying, it could be some sort of factory, petrochemical factory, it could be any sort of thing like that. So what are the limits? I'm going to let Lauren talk a little bit about the outright bans and the preemption on natural gas, and then we'll go on to the other uses that the township has at their disposal.
So I think the gentleman in the back had asked about bans. So outright bans are extremely risky. In the simple way we usually say this is because you're risking having it anywhere. And that's a little bit of an oversimplification. But what can happen is, let's say you ban gas wells anywhere. What can happen is a company can come in and challenge your ordinance, and it may be able to get what's called site-specific relief from the court if they're successful in their challenge. Whether they say, because your ordinance is exclusionary, you've completely blocked our use from going into your town. There's also a different type of exclusionary zoning challenge, which basically looks at the effect of the ordinance and whether it has sort of a similar effect. But basically, the ability to get site-specific relief puts a high risk on you being, your community, ending up with an industrial use where you really don't want it. And while we're not going to say you can't do a ban, because I'm a lawyer and I make arguments, if I have a good faith basis to do so. So I'm not going to say that there's not somewhere where there might be a good faith basis for a ban, but they are extremely risky. And a municipality and its residents need to understand what kind of risk they're bringing on if they do that. And so as far as oil and gas goes, can you just go back to the last one real fast? Sorry. As far as oil and gas goes, this is referencing specifically sort of what we talked about earlier with the where versus the how, that there is still this preemption, meaning municipalities can't regulate sort of these technical aspects of oil and gas operations. So the casing, what kind of blowout preventer you have on a well site, that kind of thing. I'm going to skip resolutions for right now, but resolutions are they're different than ordinances, and they're usually more for policy statements. So what we're going to talk about, there's different things that municipalities, different tools available to municipalities and their citizens to protect their community. So we've been talking about a lot about zoning. We'll talk a little bit more about it. There's also other types of ordinances that may be available to protect local environmental conditions or local environmental concerns. The last two we're not going to talk about too much, but I wanted to bring them up. So there's non-regulatory means, things like conservation easements. Putting an easement on a property to keep it, so like agricultural conservation easements or stream protection types of easements. And of course there's always litigation. The municipality or its citizens can sue on, go to the Environmental Hearing Board and appeal a permit, do other sorts of things. So sometimes before I did zoning, I thought it was this black box of really boring stuff. And it's actually, when you break it down, and it has sort of, some of its history isn't so great. But when you break it down to really what it can do, it can be a very powerful tool for protecting your community. As sort of we talked about earlier, the very basic part of zoning is that you set aside different parts of the municipality for different purposes, for different uses. So this is, I don't even know where Gregg Township is, but it's a good zoning map. So like, in wherever Allenwood is. But like here's your agriculture. We're going to put your commercial district here. Here's your village thing. You might have an industrial district somewhere else. So it's the idea that, you look at your municipality, you look at what resources you have, and you try to figure out what areas are best for what. And zoning is what I call an enforceable outgrowth of comprehensive planning. So you always have to have a comprehensive plan if you're doing zoning, but to really enforce the vision that's laid out in the comprehensive plan, you use zoning. And so through planning, you set out, sort of how you want the community to be for the future. There's different types of, once you have your district set out, you then have to figure out what you're going to put in each district. Obviously, you have stuff that's already there. And I'm not going to get into too much of that today. But you have to figure out, going forward, what are we going to really want to allow in this district? So you can either have a use that's allowed or not allowed. And when you get, when you're looking at, okay, if I'm going to put a use in this district, what kind of flavor of allowance, if you want to put it that way, what do I want? Do I want by right or conditional use or special exception? And so when you permit a use by right, that means that when somebody applies to, the zoning officer, there's no ability to deny the permit. I mean, unless you don't have like the right forms or whatever. But it'll become a little clear why I have that said once I get into this use. One of the crucial things, though, with a by right use, you can't impose any conditions on it. So when you put, we have a case in which that we're challenging an ordinance that puts gas wells by right in a residential agricultural district. You can't put conditions on that gas well site, but then they allowed it by conditional use in a commercial district, so you can put conditions on it in the commercial district. It's kind of backwards. Yes. Yeah. And so when you have a use permitted by conditional use or special exception, there's a couple terminology issues. Conditional use or special exception is a bit of a misnomer. It's a type of permitted use, meaning when you allow something by conditional use or special exception in a district, you are saying, we are generally expecting that this use is appropriate for this district, that it's okay to go in this district, but we're going to have a hearing process and a heftier review process to make sure that its impact is on par with what we're expecting. If the adverse impact exceeds that what you expected it to be for that use, you can impose conditions on it, or if the conditions can't reduce that impact, then you would deny it. But this is one of the other problems that we've seen is, this is the which of these things is not like the other test. But one of the things we've seen is that people will put industrial uses by conditional use or special exception in a zone that it really shouldn't be in. And then people are trying to come in and challenge it, and it just doesn't work out quite right. And what that last slide was basically trying to emphasize is put uses with other uses that they're like in districts that are designed for that particular impact. There's another type of zoning tool. So the types of zoning districts we were just talking about, the fancy name for them is Euclidean zoning districts, which comes basically from the seminal U.S. Supreme Court case on zoning. And basically you said it's polygons and things like that. There's another tool called overlay districts. Overlay districts are often used, for example, on the left we have a floodplain overlay in Tinicum Township in Bucks County. This is a historic architectural resource overlay in another area. And typically overlays come into play when you have something that you can't just like draw a square or whatever. You need to sort of protect the resource where it is. If you want to bring the slide up, the really important thing to remember here, a little too far, Tracy. Sorry again about the slides. You can't unduly disturb the expectations that are created by the underlying zoning. For example, if you have a commercial district and you have an overlay, and this was actually a case that one of my colleagues was involved in. If you have a commercial district and you have an overlay designed to protect agricultural soils, what happened in this case is the developer challenged the agricultural soils restrictions, basically saying that it was too restrictive. It basically made a de facto agricultural district out of a commercial zone. And so the court agreed. And in the end, we've actually sort of used that rationale in some of our gas well cases, saying you're upsetting expectations by putting industrial uses in non-industrial zones. So it sort of goes both ways, but you have to be careful about that when you're using overlays. They can be a useful tool, but again, you have to be aware of where they could fall. And so, as you're going through and you're trying to maybe be involved in a comprehensive planning process, a zoning ordinance drafting, this idea of science-based decision-making comes back up. And when I was helping Delaware Riverkeeper Network put together the handbook that was given out, one of the things that really struck me is really good land use planning is science-based decision-making. It's looking at where is good for this to go? What do we want to protect? How best to protect it? So it's looking at, what's in your community now? What do we want to have in the future? What kinds of natural resources do we have? Do we have a Schuylkill running through our town? Do we have a really nice bike trail that we want to protect? Maybe use an overlay to protect the bike trail. What kinds of historic and cultural features really stand out in our community, really tell a story about our community's history that we want to make sure don't get degraded? So it's all incorporating all those sorts of things and using both science and the law to get us to a good result.
So we have about 10 minutes for Q&A. So we're going to go through the next few slides kind of quickly so everybody can have a chance to ask a few questions. Do you know how to advance?
Okay, I'll try to be better about it.
No, it's fine. A lot of this we've actually already gone over, and I think we probably just want to highlight that in your science-based decision-making, it becomes more and more important as you get into these more complex land uses, like an industrial use. It's not as simple as building a house. There's a lot more involved with it, and we're going to get on that in a couple of the other slides. And also, municipalities can conduct studies themselves in order to get to the science, in order to do this analysis, or they can require the applicant to do that. If they do the studies themselves, they can require the applicant to pay for it. There's a lot of power at the municipal level, it's just a matter of using it. And then, as far as, the regulations to protect our air and water quality, and also the features that we talked about that make our municipalities and our towns unique. The thing that the Supreme Court actually recognized, there's a few things that we really need to do. We need to plan, right? We need to look at the community goals and the values. What do we want from our community? And then we need to prohibit. We need to look at those things that we really don't think mix at all with our community. And we need to thread that needle, walk that line between the outright ban and allowing for the reasonable use of those resources. We don't want to put next to preserved lands or public parks or sensitive populations like a nursing home or a playground or a park where people are outside all the time, heavy industrial use. And we want to restrict. Now setbacks, so there's a lot of talk about setbacks and buffers and how big they should be. I'm going to explain in a couple more slides, but the point is that these setbacks and buffers and these screening considerations are really based on local concerns. Like for instance, you can't say, just like the Act 13 tried to say, there's a cookie cutter and you can only put a gas well 300 feet from a house, and and there's nothing any community can do to make it a larger buffer. That's not right. And the reason that's not right is because it could be very different in one community depending on the topography, the geography, the water, where people live, and you may need to have the underlying geology. If your town uses municipal water from water wells, for instance, all of those things come into play that could change how far an activity should be from an industrial activity should be from the population and the features we're trying to protect. So on the next slide.
Okay.
So we also want to define, and this is something that actually Lauren speaks eloquently about, but one of the problems that we have, and you probably know this if you're involved at your local government level, there's a lot of wishy-washy words in the various regulations that are adopted in the zoning, in the comprehensive plans, and those wishy-washy words are exactly where applicants who want to take advantage of a situation will drive through. So we want to be as absolutely clear as we can be. We want to be clear in the definitions of our uses. We want to make sure that when we define a use, we talk about all the activities and that would come with that use, not just a few of them. We want to make sure that as new things come along, we update. Because lots of times, if you've been involved in working really hard on an ordinance and you get it adopted at your local level, and then some applicant comes in and, oh my gosh, there's a loophole nobody thought about. You need to update that ordinance. It's really important. These are living documents that need to reflect what's going on in the community. They're never set in stone. And then you also want to, as we said, you want to avoid the non-suitable district being used for a use that shouldn't be there. and beware the catch-all. Lauren, will you just explain what beware the catch-all is, because it is an important word of caution, and we only have a minute.
Okay, I'll try to keep it short, even though that's hard for me. But so it's similar to avoid a use ending up in a non-suitable district. Some municipalities have what I call a catch-all or a comparable use provision. They may say, okay, in our town center district, we're going to allow by special exception uses comparable to other ones in the district. But then they kind of rely on that a little too heavily. And instead of updating their ordinance, they rely on a catch-all. And there was a case recently involving a gas well site in Lycoming County where, and there's been a couple other cases in which gas well sites weren't really specifically addressed in the local ordinances. So then the Commonwealth Court was like, well, you can allow them by comparable use because they're like public utilities, which personally I disagree with, but that's what the court, came to the conclusion of. So you have to be very, very careful. Some of the other things I'll just, kind of briefly go through it is what kinds of standards are you going to put in? Lighting, glare, noise, hours of operation. And the questions at the bottom are important ones to really press your community on. Does the community have the ability to enforce the limits? Like, if a community puts a noise limit of 60 decibels at the property line in an ordinance, do they actually have the means to enforce it? Do they really have a noise meter? Or are they going out there with the same thing you are, an app on your phone, trying to test the thing? Because we've seen that too. Are the requirements meaningful? That goes back to being specific. If you just want to quickly skip down.
Yeah. So,
and I think we talked about a little bit.
That one, don't you think?
Yeah,
Because we only have 5 minutes.
But the one last thing is when you're dealing with conditional uses and special exceptions is to make again, the idea of clarity, specificity. So not only you, the community member, knows what's required, the applicant does. So they can't drive a truck through the exception. If you want a noise study, say what needs to be in it. If you want a geologic study, say what needs to be in it. Those sorts of things.
And another example of that is this air emissions dispersion modeling. We're just speaking with the township this past week where they have in their ordinance that there has to be an air quality analysis. But they didn't say there had to be dispersion modeling. So what that means is, okay, the applicant says there's not going to be any air impacts outside of the perimeters of our property. If they had in their ordinance that dispersion modeling was required, you would have to look at the weather, the topography, the time of year, and find out where would that air travel? Where would those pollutants be dispersed during normal, natural conditions? And they don't have that, so then they're in a box, they're caught.
And I'm going to skip to the last slide and really fast.
Yeah.
So some of the other things in the handbook, there's an example of a riparian buffer ordinance. There's floodplain protections, other things, other types of maybe non-zoning ordinances that are available. So.
Yeah, and I think this is really important for you to take home and look at, because the way that we're talking about protecting our communities from industrial development is you use all of the tools that are available. So you would perhaps adopt a really strong stormwater ordinance that would not require the capturing of stormwater and recycling of it instead of it going into the stream. You might have a floodplain protection ordinance that's much stronger than any of your neighbors because you're a community prone to flooding during a storm. So all of those things apply to all uses. It doesn't matter even whether it's a house or an industrial use, but by putting it from the back up, from making sure that you have the foundational protections in place through ordinances, you're then protecting the resources of your township, the people of your municipality and your town from all uses. Now, we want to have some Q&A and we're really short on time, so I'm sorry that we went so long, but we had to. So we'll just begin here and then we'll go down around the room.
Well, first of all, I'd like to thank you both for a wonderful presentation. The information is very useful, particularly to our community because we are getting ready to embark on a planning process. And as you know, Eastwick is under a heavy environmental load from so many of the factors that were mentioned. So I'd like to know if we can get a copy of your presentation, because there's a lot that we want to
Yes,
revisit on.
it's going to be on the website for the Schuylkill Congress.
Okay.
And then also, I know, you guys are presenting here today
Yes.
too, right? And there's been so much going on, and you've had successes, and now you're embarking on this process. We're happy to come down and speak with the neighborhood organization or whatever you want to do. Happy to do that.
Wonderful.
Two quick
Yes.
parts. So did the Supreme Court decision include any language about fracking being environmentally dangerous? And two, if you can't locate a lead smelter in a township in any zoning category, how is it that you can locate a fracking rig?
So on your first question, there was some language, I think it's maybe what in legal terms we call dicta, meaning it's not, I mean, it is pretty major that, particularly conservative justice on the Supreme Court looked at some of the stories we brought to them and said, yeah, fracking is an industrial use, it has impacts, heavy impacts. As far as your second question, that's something that's really hard for me to address in the abstract, but it's a good question. It's a good question to definitely ask and probably to really push your elected officials on particularly too.
Clearly, the site is, the effects of the operation are extending beyond the little zoning area.
Mm-hmm.
Right.
Yeah.
And that's the science there, you need to look, all right, so this lead smelter, where is the air going to go from it? What kind of pollutants are going to go into the air? How is the water going to be affected? All of those things, and then you do the same thing for the gas well. You really need to require the applicant to do the analysis to these very rigorous standards that you adopt in your planning. Anybody, when we're trying to just go around, is there anyone here
Oh,
that I'm
sorry.
missing, or?
No?
Okay.
Go ahead.
I just want to, can you cite a resource for putting a hole in the statement that the fracking itself is beneficial for the community?
You probably have a lot.
Well, yes, I mean, I think that the green book that you took, Unsafe and Unsustainable, it's written by experts, and it points out why gas drilling itself and using hydraulic fracturing cannot be done safely. And we really, at Delaware Riverkeeper Network, have studied this extensively. We have this report, we have other reports on our website, and I guess I can sum it up the way one of our hydrogeologists puts it, and this is just looking at one aspect of fracking. Because of the nature of hydraulic fracturing, where you're drilling into the ground, you're going right through the aquifer, you're going into these deep formations, and you're injecting chemicals and water and sand and other proppants down into that well. You're disturbing and distributing naturally occurring pollutants such as radioactivity, hydrocarbons, heavy metals, and you're bringing it all back up through the surface. And that is a process that has heavy industrial impacts. And we don't really understand all of what those impacts are, but one thing we do know is that the casing that we require under state regulations and the cement that's required under state regulations that's supposed to keep those chemicals, those natural pollutants, those chemicals separated from the aquifer that you've drilled through will disintegrate. It may happen quickly because of an accident, like maybe there was a void in the cement log, so it could happen in a matter of days, it could happen in a year, 5 years, but the casings in the cement, the steel casings in the cement will only last 80 to 100 years.
Basically, concrete and steel don't last forever.
So we are basically condemning future generations to polluted groundwater because we are not able, at this point in time, we just don't have the technology to do this safely. So our position is that we should have a moratorium on drilling now. We should not be allowing hydraulic fracturing now. We know that it's damaging our environment. And we know that our future generations, as well as sometimes our present generations, are having their health impacted and their resources impacted. Also, related to that, we have also reports on our website about the terrible accidents and spills that happen. So even under the best circumstances, following every rule, you can't make it safe. But here in Pennsylvania, we've really just done a terrible job in terms of trying to police this activity. And what has happened is just a lot of accidents and spills. And as a result, we're up into the multiple hundreds of confirmed water supply pollution incidents that DEP themselves admit has occurred. So we have wells that have been ruined, we have, huge, like, there was just a decision this past week in Dimick, 9 square miles of aquifer ruined by gas drilling. And the family was just finally, after fighting it since 2009, awarded $4.2 million for the damage that was done to them. And that's just one family out of 44. So, I mean, these are the kind of things that are going on with this fracking campaign. And our concern is that we need to turn ourselves to renewable energy. We need to think about clean water, clean air, and clean, sustainable energy sources, not continue down this path of pollution.
Thank you.
Is New York State being sued for their outright ban?
No, I think there was a challenge that was brought in. I don't believe it went anywhere. As right now, New York is not planning on, budging 1 inch in terms of their outright ban that they put on place. Now, they have a different constitution and a different set of regulations than Pennsylvania, and that decision was made at the executive level, and it has been banned based on science and a study and a report that was issued by the Department of Health of New York.
Can that be overturned by a future governor?
Pretty hard, because what they did is codify it in the regulations now. So it took them 7 years to develop those regulations, and then they codified in those regulations that it's banned outright. So it'd be pretty hard. It wouldn't be an easy snap like an executive order or something. It would be a whole process that would involve all the public and everything. And they have local bans there. They're allowed to have local bans. So that's how it's different from Pennsylvania. And because of that, that was one of the reasons the governor, undertook looking at a ban, because there were so many areas where it wouldn't be allowed anyway. And then the economics of the whole thing starts falling apart.
What's Governor Wolf?
Governor Wolf is, supports gas development. We're hoping, and we work with several coalitions in Pennsylvania, and we've been bringing him science and technical reports to show about the health impacts and the negative impacts in communities that are being drilled in Pennsylvania that are occurring right now and just beginning to be documented. And then we also have been bringing him information about the environmental impacts of gas drilling. And then, we're continuing to do that, and we're hoping that he's going to come around on this.
And of course, the impacts from gas development go, beyond the well site in that there's other parts that are necessary to bring the gas to market, the pipelines, right now the whole
Exactly.
thing with the maple trees, the North Hartford maple being cut down for the Constitution pipeline. Family's now losing its entire business because it's lost its maple trees. We have the compressor station, we have the refineries. I mean, look at Philly now. I mean,
That's right.
PES is trying to expand,
Oh,
all
yeah.
these things.
At Southport, they want to build
Yeah.
another terminal and more activity in terms of development of fossil fuels. Yes.
Yes, is there,
Okay.
Okay, we're at 12:36. Please, go ahead, sir. We have an engaged population, and so
I know. If you want to come up and ask us questions, we'll be happy to.
Yeah, but go ahead, sir. Go ahead and ask questions.
Yeah, good. With all that we now know about fracking and the fracking process and the damage that it has caused, not only to a specific environment, but also to the crust of the earth,
Right.
do you see a somewhat of a slowdown in the actual fracking process? Are they becoming just a little bit alarmed about what is going on and perhaps denying some of the opportunities for these guys to go out and do what's
Well, I think,
been done?
The economics is.
yeah, in Pennsylvania, we wish that they were denying permits because of environmental reasons, but they aren't. There is a slowdown in the development of natural gas right now through fracking in shale, and that's because of the economics. The cost of natural gas is depressed, and there's a glut. So there are not enough markets for it. The industry is very busy trying to develop new markets, like putting a new natural gas power plant right in Philadelphia in a neighborhood.
Bringing pipelines.
Yeah, bringing pipelines in
Yeah.
and natural gas liquids that they bleed off of the gas that they take out of particularly southwestern Pennsylvania, putting in a pipeline, the Mariner East pipeline, coming right through Philadelphia and then to the Sunoco facility, the Sunoco Logistics in Philadelphia, and then using it there. Fracking oil, in North Dakota, and then bringing it by rail in these, dangerous substandard cars across this, antique infrastructure into Philadelphia to Philadelphia Energy Solutions. All these things continue to go on, but one of the things that's happening because of the depressed gas prices and also oil prices is that drilling has slowed. Now, a benefit of that, of course, is that we get a little bit of a break in terms of this, this onslaught, this frenzy that has been going on really since 2009 in Pennsylvania. But this is not something that's being decided because of science-based decision-making. It's being decided by the drillers and the economics itself, and we want this decision to be decided based on science and based on the Article 1, Section 27, our right to clean water and clean air, and for our present and future generations to have healthy communities. So that's why we're fighting to try to get Governor Wolf and other states to look at this from that viewpoint and make it a powerful decision like New York did, to say, this is not compatible with what we want to do here. We know that it has health impacts that we don't want to accept. And I think now that we have a ban in New York, we also have a moratorium in Maryland, and there is here in the Delaware River watershed,
Is Delaware in Maryland?
yeah, it's right now, it's temporary, but it's in place. And then in the Delaware River watershed, this watershed, we have a moratorium on all gas drilling since 2010. We fought very hard, Delaware Riverkeeper Network and other organizations, to get that moratorium in place at the Delaware River Basin Commission, and we fight every day to keep that moratorium in place. If we did not have that moratorium in place, we would already have gas drilling upstream from here, and we would be paying the price in Philly's water supply, because we do have a major intake on the Delaware as well as the ones we heard about in the Schuylkill. So there is a slowdown. It's really because of economics, but it is a moment in time that actually I think gives us all the opportunity to say, okay, let's turn this ship around. Let's look at renewable and safe energy. Let's look at greening our economy, getting jobs that don't make people sick like they do at the refineries or on the oil trains or at the well sites, and instead move toward the 21st century goals of having a future and a present that's healthy. And there's no way we're going to keep our water supply clean and our river healthy and diverse and a beautiful habitat like we want it unless we really stop this fracking. So we want it to be stopped, and we want it to be stopped on science, and then that's the way we're going to make it permanent.
Thank you.
Thank you.